Good afternoon. My name is Kim Stanger. I've got 12 o'clock, which means it's time to start our next webinar series. Today we're going to be talking about practitioner recruitment with a little practitioner retention on the side. A little bit of overview of where we're going to go. We're going to talk about the laws that affect recruitment arrangements, including STARK, the Anti-Kickback Statute, some tax laws, state laws, and then we'll come back and apply those laws to common recruitment arrangements, including employment, independent contractor arrangements, and most importantly, recruitment agreements. This will involve both positions and mid-levels. We'll also talk just briefly about the STARK safe harbor requirements for retention agreements, some common terms in the arrangements. We'll wrap up with a few suggestions concerning compliance when it comes to recruitment agreements. By way of preliminaries, you should have received written materials. If you didn't, send me a quick email and we'll make sure that you got those. The written materials include our PowerPoint slides for today, a copy of the STARK recruitment and retention safe harbors, and selected commentary from CMS concerning those safe harbors, the Anti-Kickback Statute recruitment safe harbor, and some OIG commentary and advisory opinions concerning that, and a page from the IRS's Healthcare Provider Reference Guide that talks about the tax implications with 501c3s and recruitment agreements. Like our other presentations, this presentation will be recorded and available for download in the future in case you haven't got anything better to do this weekend. It's at our website, and if you have any questions, feel free to submit them using either the chat line feature in this broadcast or just email me directly. We won't take questions during the program, but I'd be happy to respond to you offline. Finally, this presentation is provided for educational purposes only. It doesn't constitute legal advice and doesn't create an attorney-client relationship. And now that my risk manager is happy, let's talk about recruitment agreements. Because sometimes you have situations where you've got to try to get that physician to come to your particular area in order to provide services in your area. But anytime you're paying physicians or other practitioners anything, and they are potential referral sources, you've got to be aware of the Anti-Kickback Statute and the STARK statute. But it's not only these federal laws, the fraud and abuse laws, you've also got to be concerned about federal and state tax laws, as well as state laws that may apply to fraud and abuse type issues. Case in point, United States versus Weinbaum, which is a major case from 2003. That's when it was initiated back in San Diego. This was a situation where the government sued Tenet Alvarado Medical Center, its CEO, and certain others for anti-kickback statutes violations arising out of recruitment arrangements. Allegedly, the defendants paid $10 to $15 million over a 10-year period to recruit over 100 physicians to that particular area. Many of those deals resulted in money flowing to existing physician practices, and the arrangement or the allegation was that this was really done to induce referrals for those other physicians. Well, after many years and 2 trials, the case ultimately was resolved, but not before the assistant administrator pled guilty to conspiracy. CEO and Tenet, after 2 trials, both of which resulted in hung juries, they ended up settling, whereby Tenet paid $21 million and sold the hospital, but allegedly the hospital spent $30 million in defending the cases to get to that particular point. The bottom line is that be careful anytime you're entering into recruitment agreements, especially if it involves existing physician practices, because you've got to be concerned about STARK and the Anti-Kickback Statute. STARK states that if you're a physician cannot refer a patient to an entity with which the physician or a member of the physician's family has a financial relationship if that referral is for certain designated health services for which payment may be made under Medicare. And if they do have that financial relationship and provide a prohibited referral, the entity that provides services in response to that referral cannot submit a bill for payment to DHS for that DHS rendered pursuant to that prescribed referral, unless you've structured the deal to fit within a regulatory safe harbor. Now, STARK doesn't prohibit the financial relationship. It just says, hey, physician, if you or a member of your family have a financial relationship with this provider of designated health services, you can't make referrals to that entity, and that entity can't bill for those services unless you've structured the deal to fit within a regulatory safe harbor. If you do that, the whole parade of horribles can rain down upon your head. Stark is not a criminal statute. You won't go to jail. It's not like Tenant Alvarado case. But you can't bill for those services. And if you did bill improperly, then you've got to repay the money that you received. So in the context of a recruitment agreement, if you entered into this agreement with a physician a couple of years ago, but that recruitment agreement did not satisfy the required Stark safe harbor provisions, then you would have to go back and repay the government all the money that you received from Medicare during that 2-year period based on referrals or orders from that particular physician. The penalties can add up awfully quickly. You've got an affirmative obligation to report and repay within the 60 days, and if you fail to do that under Stark, you can get hit up with fines of $15,000 for each claim that you submitted, and physicians can get hit up with a penalty of $100,000 for each scheme, each arrangement that was designed to result in those prohibited referrals. You can also be excluded from Medicare and Medicaid, and it may trigger a False Claims Act claim, which can subject you to additional penalties, like we'll talk about in a few minutes. Now, Stark is relatively limited in its application. Stark only applies to financial arrangements with physicians or their family members, not non-physicians. It applies to MDs, DOs, podiatrists, oral surgeons, dentists, optometrists, chiropractors. It also applies to financial arrangements with any of their family members. So Stark does not apply to recruitment of non-physicians, such as Midlevels, but at least it doesn't apply directly, but Stark may apply indirectly, because if you're dealing with a physician group and that physician group is recruiting that mid-level in, and you're basically paying that group or subsidizing that group's costs of recruiting that mid-level in, then that may create a financial relationship with that physician practice. So you've got to be concerned about Stark's application indirectly in those circumstances. Well, Stark says if you've got that type of arrangement and you want to referrals and to bill for those referrals from that entity, you've got to make sure that you structure the deal to fit within a safe harbor. There's lots of Stark safe harbors, only some of which are potentially applicable to recruitment agreements. The most important of which, for purposes of today, are the employment safe harbor, personal services safe harbor, most importantly, the physician recruitment safe harbor. There's also a physician retention safe harbor, but those aren't the only ones. Depending on the circumstances and how you structure the deal, the benefits you want to provide, there could be safe harbors that are implicated, like EHR donations, OB malpractice insurance, ownership or investment interest in a rural provider. If you're a physician group and want to recruit a physician in, then really the safe harbor you're going to be looking at are services by another physician in the group or in-office ancillary services exception. In order to satisfy Stark, you only need to make sure that your arrangement fits within one of those safe harbors, but each financial relationship has to fit within a safe harbor. So if, for example, you're doing a physician group and you want to contract with a hospital to do a joint recruitment for a physician, then you've got to look at not only the financial relationship between the hospital and the physician group, but also the financial relationship between the physician group and the recruited physician. Both of those would need to fit within a regulatory safe harbor. That is Stark. You've also got to be concerned about the Anti-Kickback Statute. The Anti-Kickback Statute is much broader than Stark. It extends to entities beyond just physicians. The Anti-Kickback Statute says you cannot knowingly and willfully solicit, offer, pay, or receive remuneration in exchange for referring an individual for items or services covered by federal health care programs unless you structure that transaction to fit within a regulatory safe harbor or you obtain a favorable advisory opinion. It is incredibly broad. Anytime you are giving anything of value to a referral source for any federal program business, you got to be concerned about the Anti-Kickback Statute. Now, the Anti-Kickback Statute, unlike Stark, is an intent-based statute. It only applies if you knowingly and willfully solicit, offer, or pay with the intent to induce the referral. But the courts have interpreted that very broadly. So the anti-kickback statute applies if one purpose of the transaction is to induce improper referrals. Even though you have 99 legitimate reasons for doing what you're doing, if one purpose of the transaction is to induce improper referrals, then that is a stark violation unless you've structured the deal to fit within the safe harbor or you've otherwise gotten an advisory opinion that protects you. What's the penalty for an anti-kickback statute violation? Well, you can go to jail for this one. Criminal penalties, 5 years in prison, a $25,000 fine. In addition, you can get hit up with civil penalties under the Civil Monetary Penalties Law, which are treble damages, $50,000 per violation, and it's an automatic exclusion from Medicare and Medicaid. And in the wake of the Affordable Care Act, the anti-kickback statute violation is an automatic False Claims Act violation, which means you can get hit up with additional penalties of $5,500 to $11,000 per claim that you submitted while you were in violation of this, plus treble damages, and you could be subject to key TAM lawsuits, suits by employees or others who are suing you on behalf of the government because of your violation. Well, so what you want to do if you've got an anti-kickback situation, you want to try to structure the deal to fit within one of the anti-kickback safe harbors. For example, there's anti-kickback safe harbors for employment arrangements, personal services arrangements, recruitment arrangements, OB malpractice insurance subsidies, and certain others. Just like Stark, you only need to satisfy one safe harbor. It is not absolutely essential that you satisfy an anti-kickback safe harbor. It's just if you don't, you're not going to be safe. And the question is one purpose of the deal to induce referrals? And that's a tough burden to overcome. All right, in addition to those issues, you also got to be concerned about tax issues, particularly if you are a 501c3 entity, because as part of your obligation as a charitable entity under the 501c3 regulations, you need to make sure to maintain your tax-exempt status that you're operated for the public benefit, not for private benefit. The IRS has interpreted that excessive payments to private practitioners may be private benefit, which could result in the loss of your tax-exempt status. So you want to make sure that you're not overpaying these private practitioners because it could jeopardize your 501c3 status. Now that doesn't happen very often. That's kind of the nuclear option that the IRS could do. More likely they would impose intermediate sanctions. The statute was amended some years ago to allow the IRS to impose an excise tax on organizations that provide excess benefit to certain disqualified persons. Disqualified persons include persons who exercise substantial control over the organization, such as officers, directors, but it could include physicians, particularly if those physicians have a lot of clout at the organization or they serve in management, if they're, for example, chief of staff, a medical director, or somebody like that. In that situation, they may be considered a disqualified person and may be subject to an excise tax along with the organization. The government in Revenue Ruling 97-21 specifically said, okay, it may be appropriate in certain cases to pay money to recruit physicians, but we're going to look at those on a case-by-case basis. Some of the factors that the IRS is going to consider in evaluating whether or not there's an excess benefit that's been paid or private inurement. They will look at the demonstrated community need for the practitioner. Was the total recruitment package reasonable in light of the facts and circumstances? Was that agreement approved by an independent hospital board that oversaw the recruitment arrangement and made an independent judgment? Do the arrangements violate fraud and abuse laws? And is the entire agreement memorialized in a single written agreement that is negotiated at arm's length, that there's no undocumented side agreements? The IRS has also published a healthcare provider reference guide. I've given you a copy of the relevant page in which they reaffirm that if you're evaluating recruitment incentives, you're a 501c3, you ought to make sure that you consider your community need, and note that that's the community need, not necessarily the hospital need. It's not a question of whether or not the hospital has a particular specialty on their staff. It's whether or not that specialty is available in the community. Whether it's provided as part of an arm's length transaction consistent with your written policies, and it will not result in excessive compensation to the physician, such as unreasonable income guarantees. Okay, in addition to the federal laws, you've got to be concerned about particular state laws. So before you enter into these recruitment agreements, make sure that you've checked potentially relevant state laws. Most states have their own version of an anti-kickback statute, which may or may not apply. Some states have their own version of Stark that would limit self-referral situations. For public entities, if you are a public hospital, for example, your constitution or state laws may have prohibitions against using public funds for private individuals. Now, most of the time, that would exclude things like employment arrangements or contracts for services, but depending on how your AG interprets that, it could be interpreted to apply to recruitment incentives to get them to come in. In addition, if that recruitment agreement is structured as a loan, most states have public finance limitations that prohibit loaning public money to private individuals. So it may limit your ability to structure that recruitment agreement as a loan. There may be other state statutes that are out there. Just make sure that you're aware of those. All right, with that bit of background talking about the laws, let's talk about applying those laws to particular arrangements. First, let's say you just want to bring in that physician as an employee or that practitioner as an employee. Well, that's pretty easy to do. Not real magic to that. You'd probably want to just rely on the employment safe harbors. Under Stark, pretty easy to do. You don't even need a written agreement if you don't want to. The compensation does not have to be set in advance. It just has to be a bona fide employment of the physician or their family member. It has to be for identifiable services. The agreement has to be commercially reasonable, even if no referrals were made. So you can't just do this to generate referrals, but there has to be a legitimate, commercially reasonable basis for doing this type of agreement. The remuneration has to be consistent with fair market value and not determined in a manner that takes into account directly or indirectly the volume of value of referrals. There's the real rub when it comes to recruitment agreements, because to fit within the employment agreement safe harbor or the independent contractor safe harbors, you can only pay the physician or practitioner fair market value. Well, what happens if you need to bring them in at above fair market value because you can't get them to come to your particular area unless you pay them above fair market value? Well, in that case, you may have to look for a different safe harbor. We'll talk about that a little bit later. Under the Anti-Kickback Statute, if you're bringing them in as an employee, that makes it really easy because the Anti-Kickback Statute does not apply to bona fide employment arrangements. Now, note that it has to be a bona fide employment arrangement. There is some OIG commentary out there in which they suggest, I haven't seen any cases where they've actually enforced it, but they've suggested that if you're doing this deal really just as a means to get in referrals and you're overpaying in order to get referrals, that really isn't a bona fide employment arrangement, and therefore they reserve the right to come in there and take a look at it. I think that would be a rare case, but in order to comply with Stark, you're going to want to make sure that you're paying fair market value for the services anyway. As far as tax laws, just remember that anytime you're offering these recruitment incentives, particularly in an employment context, chances are they're all going to be taxable as W-2 wages. So when you offer to pay loan forgiveness or make a loan, or if you're paying relocation expenses or giving them a sign-on bonus, or you're doing a repayment of loans, all of those things are probably going to be considered taxable benefits that you're providing to your employee, which means that you're going to have to factor in the tax deductions on that, the tax withholding on all of that. For any of those situations, the key there is to check with your tax advisor and making sure that you're taking into account the relevant tax considerations for any of those benefits that you're providing. If you're a 501c3 entity, make sure that you're going to document fair market value so that you don't run into problems with the excise tax or private inurement and that stuff. All right, that's if you're bringing them in as an independent employee. What about if you're going to bring them in as an independent contractor, either to provide services part-time or full-time, or maybe you're bringing in this practitioner, they're not going to be able to make it on their own for a little while, so you're going to hire them as an independent contractor on a part-time basis to provide certain services for you as a means to help supplement their income. Maybe you're going to hire them as a medical director, or you're going to hire them as to provide call coverage or to provide part-time services at the hospital on an independent contractor basis, not as an employee. Well, if it's a physician, then you've got to structure the deal to fit within Stark. There's a couple of potentially relevant Stark exceptions. The first is the Stark Personal Services Safe Harbor. It applies if you have a written agreement signed by the parties for the services between the entity and the physician or family member. That agreement has to be for at least 1 year. Now, you can terminate it earlier than that, but you can't renegotiate the terms or enter into a new agreement during that 1-year period. That's designed to protect against situations where you have a series of short-term contracts and you manipulate the compensation based on referral patterns. The agreement has to cover the services that are going to be provided. The aggregate services cannot exceed those that are reasonable and necessary for legitimate business purposes. So you got to have a real and legitimate need for those services that you're contracting with the physician. The compensation has to be set in advance. It cannot exceed fair market value, and it cannot be determined in a manner that takes into account the volume or value of referrals. So you got to make sure the compensation terms are set in advance and it's documented by a written agreement before you enter into the agreement, before you begin paying. That's the personal services safe harbor. There's actually a second safe harbor that applies to independent contractor arrangements. It's the fair market value safe harbor. And in a lot of ways, it's easier to satisfy than the personal services. In order to satisfy this one, you've also got to have a written agreement signed by the parties. The agreement has to specify the length of time, and unlike the personal services safe harbor, the fair market value safe harbor says that you can have that agreement for any period of time, provided the parties enter only one agreement for the same services within 1 year. So you could have a 3-month agreement and have that agreement renew perpetually during that period. You just can't change the terms of that within the 1-year period. The compensation has to be set in advance, can't exceed fair market value, and can't be determined based on referrals, and the arrangement has to be commercially reasonable, and the arrangement does not violate the Anti-Kickback Statute. Okay, that's for Stark if you want to have an independent contractor arrangement. What about the Anti-Kickback Statute? Well, to satisfy that, which would apply not only to physicians but also practitioners, you've got to have a written agreement signed by the parties. The agreement has to be for at least 1 year. It has to specify all services performed by the practitioner. If the practitioner is performing the services on a periodic or part-time basis, you're supposed to specify the schedule, length, and charge for such intervals. The aggregate compensation must be set in advance. Now note, that's different than Stark. Under Stark, it's just that the compensation has to be set in advance, meaning the formula. Under the Anti-Kickback Statute, the aggregate compensation has to be set in advance. That means you generally can't have a productivity-based compensation model under the Anti-Kickback Statute safe harbor, because the aggregate compensation would not be set in advance. The aggregate services cannot exceed those that are reasonably necessary to accomplish a commercially reasonable purpose. Now remember that unlike Stark, if you can't fit within the Anti-Kickback Statute safe harbor, it doesn't necessarily mean that you violated the Anti-Kickback Statute. The ultimate test is whether one purpose is to generate improper referrals. So if you can't fit within the Anti-Kickback safe harbor because, for example, you want to pay an independent contractor based on productivity, you just need to ensure that there's no improper intent to generate referrals. Beware your discussions or your documentation that might suggest you're doing this deal to generate referrals. You want to structure the deal to come as close to the safe harbor as you can, and most importantly, document the community need, why you need to do this deal, and document that you're paying fair market value for the services that are actually being performed. When it comes to taxes, remember that if you're paying an independent contractor, you're probably going to have to claim all of those on a Form 1099, so that make sure that that practitioner is going to pay the appropriate taxes on it. If you're a tax-exempt nonprofit entity, you're going to want to, again, document your fair market value to avoid any kind of claim that you are paying excess benefits. All right. Those are recruitment, independent contractor arrangements where you're paying for services that are going to be provided. Most of your recruitment arrangements, however, don't fit within those. Situations where maybe you're going to pay a one-time payment as a recruitment incentive. Hey, you move here, we'll pay you, $50,000 to come here, one-time payment. Or maybe you're going to pay their expenses, like student loans, do a student loan repayment. You're going to pay their relocation expenses. You're going to pay certain practice startup expenses, pay recruiter fees, provide them with insurance or subsidize their insurance. Maybe you're going to provide them with an income guarantee, or you're going to provide items or services to support the recruit for a certain period of time. Maybe you're providing free or subsidized space or equipment, information technology, administrative support, marketing, whatever it might be. For those types of situations, you're not going to be able to fit within those other safe harbors, so you need to structure the deal to fit within, if it's a physician, the Stark recruitment safe harbor. Now, the Stark Recruitment Safe Harbor is pretty complex. I've given you a copy of that in your materials. But the Stark Recruitment Safe Harbor only applies to payments that are made by a hospital, FQHC, or a rural health center. It doesn't apply to a group's recruitment payments. It only applies to these payments by hospitals, FQHCs, or RHCs. It has to be paid. The payment has to be to induce that physician to relocate to the hospital's geographic service area as defined in the regulations. And there's a complicated formula for determining the service area based on contiguous zip codes. So it's to induce that physician to relocate to the geographic service area and join the medical staff. In order to fit within the safe harbor, they have to move their practice from outside the geographic area at least 25 miles into the service area, or they still have to relocate from outside the service area into the service area, but if it's less than 25 miles, at least 75% of the revenues have to come from services from new patients as defined in the regulations. Now, that's the general rule. There are exceptions that if you are going to recruit a resident or a physician who's been in practice for less than 1 year, or certain former government employees, then they don't necessarily have to have that, you don't have to satisfy that relocation requirement, but that's a limited exception. Your recruitment agreement has to be in writing, signed by the parties. It cannot be conditioned on or based on referrals to the hospital, and it cannot be restricted. You can't restrict the recruit from making referrals or having med staff membership in other entities, except as allowed by 42 CFR 411.354D4. The concept here is, look, the government's going to give you some slack in recruiting this person, but if you're going to recruit the person because the community needs them, we don't want you to limit that person's ability to provide services elsewhere. Now, there is a limit on that, if you're hiring that person to come in as your employee or an independent contractor, this 42 CFR 411.354 can require them to make referrals to you, not necessarily preclude referrals to others, but you can require them to make referrals to you unless certain conditions are satisfied. Now, that's the general recruitment if you're just going to recruit that person to start their own practice. If you're going to recruit that person into an existing physician practice, so you're doing a joint recruitment agreement with another group to bring that person into an existing physician practice, then you've got to satisfy some additional requirements. Remember, the government's concerned about these recruitment agreements where you are recruiting this physician to join an existing group. They're concerned that this may really be a way to subsidize that existing group and to get referrals from that existing group. And because of that, we're going to put in place some additional safeguards that have to be satisfied. So if you're going to recruit that practitioner, that physician into an existing practice, you've got to in addition, you've got to satisfy the following. That agreement has to be signed by all the parties, including the group practice. The remuneration paid is paid to or passed through to the recruited physician. So generally, this money is going to go to the physician, not to the existing physician practice, because we don't want you to subsidize that practice. The exception for that is you can reimburse that group for any actual recruitment costs that they incurred in recruiting that physician, things like headhunter fees, airfare, lodging, and the like. But it's the stuff that they had out of pocket, you can reimburse for them. You can't otherwise cover their overhead costs, though, and you can't reimburse them for the time they spent in recruiting that physician. That wouldn't fit within the recruitment safe harbor. You could theoretically pay them under a separate independent contractor agreement for their time, but that would have to be done by a separate agreement and fit within the independent contractor safe harbor. Now, if you're going to pay an income guarantee, which is quite frequent, quite common when you're doing these deals into groups, you've got to make sure that you limit any allocated costs as part of that income guarantee to only the actual incremental costs attributable to the recruited physician. Again, the theory here is, look at group, we will allow you as part of that income guarantee when you're setting the physician compensation, we will allow you to factor in the cost that you actually incurred in bringing that physician in, the additional incremental costs it took to bring that physician in, like recruitment fees, or if you have to go out and rent more space, the additional space, or if you have to hire more people because of this person, then it's the additional people. But you can't factor in just overhead. we're not going to allow you to basically give this person a part of the overhead, and the hospital is essentially going to subsidize your existing physician. You can only pay for the additional costs that are directly attributable to bringing that physician in, but not any of the existing overhead. Now, there is a limited exception. If you're going to recruit that physician to replace the physician in a rural area or HPSA, you can allocate certain overhead costs, but it's limited. You can either, in that situation, as part of the income guarantee, you can either charge the actual additional incremental costs, or you can charge the lower of a per capita allocation, or 20% of the practice's aggregate costs. So if you've got, for example, 4 physicians in that area, it's a HPSA or a rural area, you want to simply, for purposes of the income guarantee, assign this new physician 1/4 of that practice income, then you can go ahead and do that, but it's capped at 20% of the practice's aggregate costs. That is an exception and doesn't apply very much. In addition, that group has to maintain records of the cost, and you pass through amounts for 5 years so the government can come in there and take a look at it if they want to. If you're going to recruit into an existing practice, you've also got to satisfy the following criteria. The remuneration cannot be determined based on the referrals by the recruited physician or the physician practice. The practice may not impose practice restrictions that unreasonably restrict the physician's ability to practice in the geographic area, because that's why we're going to cut you some slack and let you do the recruitment agreement. It doesn't make much sense to give you some slack, let you recruit them, but then prohibit that physician from providing services in the area. Now, it used to be that you couldn't even have non-compete agreements in these joint recruitment arrangements where you're recruiting the physician into the group, but a few years ago they changed that. So now you just can't impose unreasonable practice restrictions. The government, CMS, in the citations there, they've actually said that the following would be okay. You can include these. You could have reasonable restrictive covenants, presuming that those restrictive covenants are consistent with applicable state law. You could restrict moonlighting. You could place prohibitions on soliciting patients or employees, confidentiality provisions. You can include that in the arrangement. You could require the physician to repay any losses to the practice if they leave. You could require the physician to pay liquidated damages if the physician leaves the practice. Those are not deemed to be unreasonable restrictions, so you could include that. All right, so that is the Stark Recruitment Safe Harbor. A couple of points. Note that that is limited. That Stark Recruitment Safe Harbor does not apply if the recruitment payments are coming from an entity other than a hospital, RHC, or FQHC. For example, a recruitment by a group, or a recruitment by a nursing home or a home health agency or some other entity, they can't rely on that Stark Safe Harbor. They'd have to fit within another Safe Harbor. It does not apply if the physician is already on the medical staff, because the Safe Harbor says it was done to induce that person to relocate and join the medical staff. So if they were already active staff member or have courtesy privileges, then you can't use that recruitment Safe Harbor. What about telemedicine? Well, presumably if they're a telemedicine member, medical staff member, then the Safe Harbor wouldn't apply, but the commentary hasn't extended to telemedicine so far. Note that it only applies if that physician relocates from outside the geographic service area into the service area. So this was designed to protect against cross-town referrals. The exception to that, again, is if it's a resident or a physician who's been practicing less than a year or was employed by the federal agency for a certain period of time. And Stark does not apply to recruitment of a non-physician. So, for example, if you've got a joint recruitment of a mid-level, Stark, it may be triggered, but you're not going to be able to rely on this recruitment agreement Safe Harbor. We'll talk about that more in a few minutes. Also, if you're going to rely on the Stark Safe Harbor, you've got to be careful about changing the terms of the agreement once the physician arrives. There was actually a Stark advisory opinion that came out where the physician came into the area because of some circumstances. They wanted to change some of the repayment obligations so that they were more favorable to the physician, and the government said, no, you can't do it. The whole recruitment Safe Harbor is done to induce the physician to arrive. Once that physician is there, then there is no purpose for amending the agreement. If you're going to amend the agreement after they're there, it's no longer an amendment to induce that physician to come to the area. and therefore you would have to fit within some other safe harbor, and it's simply not going to work. The bottom line is, don't be monkeying with your recruitment agreement after that physician arrives. You need to make sure you're enforcing it according to the terms of the existing agreements. Well, that's the Stark safe harbor. You've also got to be concerned about the anti-kickback safe harbor. The anti-kickback safe harbor is far more narrow than the Stark safe harbor. The anti-kickback safe harbor generally was designed to allow for recruitment of physicians into rural areas or HPSAs. So the anti-kickback safe harbor only applies if it's a payment to induce a practitioner who has either been practicing for less than a year or another practitioner if they're going to relocate into a HPSA, a healthcare service shortage area that's served by the ND. In order to satisfy this safe harbor, the written agreement has to be signed by the parties. It has to specify the terms. At least 75% of the revenues have to come from new patients. At least 75% of the revenues have to come from patients that are in the HPSA or are part of a medically underserved population or that are in a medically underserved area. The benefits have to be provided for no more than 3 years. The terms can't be renegotiated within the 3-year period. You cannot require referrals to the entity paying the remuneration, but you may require the practitioner maintain medical staff membership. You cannot prohibit referrals to or medical staff membership at other entities. The benefits can't be based on referrals for federal program business. You can't discriminate against program beneficiaries. And that arrangement cannot benefit another entity in a position to generate referrals. What does that mean? You cannot have a joint recruitment agreement or recruit a physician into an existing practice and satisfy the recruitment safe harbor. That won't work. Well, what happens if you can't satisfy the recruitment safe harbor? Because, quite frankly, that's pretty darn hard to do. Well, again, remember, it's not absolutely essential that you satisfy the recruitment safe harbor so long as you're not doing this to generate referrals. So the key there, if you can't satisfy the safe harbor, make sure that you document community need, that there's a legitimate need for doing this, not just to generate referrals. How do you demonstrate that community need? Well, if your community is designated as a HPSA and you're recruiting for that one of those specialties within the HPSA, then that's going to help. If the population ratio in the community for a particular specialty is below the recommended or standard ratios, if the demand for a particular medical service, if there's a demand plus a documented lack of service or long waiting periods, that can help. If there's an anticipated reduction in the number of physicians due to anticipated retirement or whatever in the next few years, then that will help. If there's a demonstrated reluctance of physicians to relocate to the area, you've tried to get specialists in and you can't do it, and so you need to pay them more than fair market value in order to get them to your area, then that will help. If there's evidence of a lack of physicians serving an indigent or Medicaid patients in the service area, so there may be specialists there, but none of them want to take Medicaid, and you've got to bring somebody in order to provide care to indigents, then all of those are factors that may help document the community need and justify doing a recruitment arrangement even if you can't fit within the safe harbor. In the OIG Supplemental Compliance or Hospital Compliance Program Guidance, they've given you some additional factors to consider in evaluating anti-kickback compliance. Remember that anytime you're doing one of these deals, if it's a physician, you got to satisfy Stark, but that doesn't mean you can ignore the anti-kickback statute. Because even if you satisfy Stark, there could still be an anti-kickback violation. So anytime you're doing a recruitment deal and there's going to be referrals for federal program business, you have to be concerned about the anti-kickback statute. The OIG has said that in evaluating a recruitment agreement, you should consider the following factors: the size and value of the recruitment benefit. Does the benefit exceed what is reasonably necessary to attract a qualified practitioner? Has the facility previously tried and failed to recruit or retain the physician? What about the duration of payout for the recruitment benefit? If you're locking that physician in and that benefit extends for a long period of time, more than 3 years, then it's probably going to be suspect. Whether the remuneration directly or indirectly benefits other referral sources. So are you bringing that person in not because you necessarily need the service, but because you're effectively subsidizing this other physician practice so that you can get referrals from that other physician practice. What about the practice of the practitioner that you're going to bring in? Is this new physician going to come in with new or few or no patients, or are you basically bringing this physician in so that they're going to bring all their patients and capture all these additional referrals? Is the physician relocating from a substantial distance, so referrals that are unlikely to follow him, or are they just coming across town, so you're really paying to get all of his existing patient base? Does the physician have an existing stream of referrals in the service area? Finally, the need for the recruitment. Is the recruited physician specially needed for adequate care in the community, or do patients already have access to comparable services through somebody else? Anytime you're doing joint recruitment deals with group practices, you got to be especially careful because you're not going to fit within the anti-kickback safe harbor. So make sure that you, when you structure those deals, that they are not structured as a way to simply subsidize the existing group practice. All right, that talks about recruiting physicians. What about recruiting mid-levels? Mid-levels are becoming increasingly important because of the physician shortage and the Affordable Care Act. Well, remember, Stark doesn't apply directly to mid-levels, but the Anti-Kickback Statute does. So anytime you're going to recruit a mid-level and that mid-level is going to refer federal program business to you, you need to try to structure the deal to fit within an anti-kickback safe harbor, any of those anti-kickback safe harbors we talked about earlier. And if you can't fit within the safe harbor, you want to make sure that you document the community need, all of those things we just talked about. Well, what about Stark? The Stark safe harbor is not going to apply to recruitment of mid-levels. Stark doesn't apply to mid-level. So if all you're going to do is just pay the mid-level to come in and set up their own practice, maybe it's a nurse practitioner or a PA and they're going to set up their own practice, not be connected with an existing practice, you don't have to really worry about Stark. On the other hand, if you're going to pay that mid-level to come in and they're going to join an existing physician practice, then you do have to worry about Stark. The government has said that Stark may apply if the payments subsidize an existing physician practice's cost of recruiting and employing mid-levels. That is going to create a financial relationship with that group, and there is no safe harbor that's going to apply. So that creates problems if you want to comply with Stark and you're going to bring in a mid-level to join an existing physician group. The safer thing is to assume that you simply can't do it. Now, you could maybe try to push the envelope a little bit. One could argue that as long as, even though that physician assistant or that mid-level is joining an existing group practice, that if your payments are going directly to that physician assistant or mid-level, and it's not in any way subsidizing the payments that are coming from that physician practice, so you're not paying an income guarantee, you're not reimbursing that physician practice for any expenses or anything like that, then you could argue that Stark is not implicated in that situation. But it's a tough sell, and so be very careful when you're recruiting mid-levels into referring physician groups. All right, up until now we've talked about recruiting practitioners into your area. What about if you've got a practitioner in, but that practitioner is threatening to leave? What can you do to make sure that they leave? Can you give them incentives like you were going to recruit them? Can you give them incentives to stay? Well, under the anti-kickback safe harbor, under the Anti-Kickback Statute, there is no safe harbor for practitioner retention. That means if you want to be safe, you're going to want to try to fit within another safe harbor, maybe an employment agreement, or you structure some kind of independent contractor arrangement where that physician provides services, or that practitioner provides services and you supplement their income for legitimate services at fair market value. Because you can't fit within a safe harbor, or if you can't fit within a safe harbor, you need to make sure that there's no improper intent to generate referrals. What does that mean? You're going to probably want to document community need, that community is going to be adversely affected if this person leaves. As long as you're documenting community need and or documenting fair market value in order to payments to keep that physician there, then you're probably going to be okay. We haven't gotten really much anti-kickback guidance on this, but as long as you kind of apply those same type of standards for physician recruitment in order to document community need, you're probably going to be okay under the Anti-Kickback Statute. but you still got to be concerned about Stark if you're paying in order to retain a physician. There is actually a safe harbor that applies for retention under Stark, but it's kind of hard to satisfy. In order to satisfy that safe harbor, you've got to, it only applies to payments that are made by a hospital, an FQHC or an RHC, and those payments are made directly to the physician who's a member of the medical staff to retain that physician's practice in your geographic service area. The area served by the hospital has to either be a HPSA, regardless of the physician's specialty, or you have to have a demonstrated need for the physician per an HHS advisory opinion. So if you're not in a HPSA, you could go out and get an advisory opinion where they say, yeah, okay, you can and should pay in order to be able to retain that physician. At least 75% of the patients have to reside in an MUA or are members of a medically underserved population. And you've got to have one of two things. Either there's got to be a bona fide offer for that physician to go someplace else, and that offer has to satisfy certain criteria, or that physician has to provide you with a certain written certification that they've got a bona fide employment opportunity someplace else. Among other things, that bona fide employment opportunity has to require the physician to relocate their practice at least 25 miles outside the geographic area. It has to contain certain details concerning the opportunity, the steps taken by the physician to effect the opportunity, the date of relocation, and information sufficient to verify the opportunity. The hospital has to take reasonable steps to verify the opportunity, and both under the certification or the written offer situation, there's limits on what you can pay that particular physician. Under the bona fide offer, the most that you can pay the physician, the payment that you're going to give them to stay, it cannot exceed the lower of the amount obtained by subtracting the current income from the offer, so you can't pay them more than they would make someplace else, and or the reasonable costs the hospital would have to recruit the new physician. If it's a situation where the physician is simply providing written certification that they have this other opportunity, the retention payment cannot exceed the lower of 25% of the physician's current income or the reasonable cost the hospital would have to recruit the new physician. There are additional requirements that they have to satisfy that basically track the things we talked about for recruitment safe harbor. It's, again, pretty hard to satisfy that when it comes to Stark. So if you're not going to be able to fit within the retention safe harbor under Stark, and it's a physician, you got to look for another safe harbor, and maybe an employment contract. Maybe you come up with an independent contractor arrangement where you can help subsidize the physician's practice by contracting with them to provide legitimate services at fair market value, either under the personal services exception or the fair market value exception. If you can't do any of that, nothing seems to work, you can always go to the government and ask for an advisory opinion. CMS has said, hey, in appropriate situations, we may authorize retention payments even though you cannot fit within the safe harbor or do not otherwise fit within a Stark exception. Anytime you're paying for tax or practitioner retention, you've always got to be concerned about the tax issues. The IRS has not really addressed retention payments per se, but the general rules probably still apply. You can't pay more than fair market value. If it's a recruitment situation, retention situation, probably you're going to be okay if you apply the same types of considerations that would apply in a recruitment situation. So if you need to retain that physician and you need to pay them some money in order to retain them, document community need, make sure you have a written agreement negotiated at arm's length, that the payments are reasonable under the circumstance, that there's adequate board supervision, and so forth. All right, that gives you kind of an overview of the legal issues. Let's talk about some of the common recruitment terms in the few minutes that we've got left. Well, generally, when you're doing a recruitment agreement, not necessarily an employment agreement or an independent contractor arrangement, but if it's a recruitment arrangement, you're going to want to have these types of terms in your agreement. You need to have a written agreement that's signed in advance by all the parties. That means if you're going to do a joint recruitment agreement, it needs to be signed by the group in addition to the physician and you guys. That contract should define what the practice requirements are. What are you going to require that person to do? You need to require them to relocate to the geographic area served by the entity, and that they need to maintain a full-time practice, presumably it's full-time, in the specialty, in the community for a defined period of time. Usually to comply with the Anti-Kickback Statute, it's not going to be more than 3 years. You're going to want to require them to maintain medical staff membership at your organization. You might want to throw in there things like call obligations. If you're going to recruit them into a group, make sure that you consider the possibility of what happens if, fine, they come into the group, but a year after that, they leave. Does that mean that, is that going to violate the terms of the agreement? Usually, you're going to want to structure the deal so that it contemplates a situation where the physician comes in, they are at the group, but if they leave within that 3-year period, that they can leave that group, they can go out and continue to practice in the community, and it's not going to trigger the repayment obligations. Otherwise, it may run afoul of the Anti-Kickback Statute or other issues if you're going to require repayment if only so long as they stay at that particular group. The agreement's going to want to define the qualifications, things like you want to make sure that they maintain their licensure, that they've got DEA certification, that they're not excluded, they maintain insurance or any other qualifications that you need to make sure that they maintain to be able to practice. You're going to want to include the terms that are required by the safe harbors. This is where you actually pull out the safe harbors that I've given you and go through the checklist and make sure you've got required terms in that agreement. Things like they don't discriminate against government program beneficiaries, that there's no referral requirement unless it's allowed under the particular exceptions, that they maintain the documentation as necessary for 4 or 5 years, depending on the nature of the transaction, that they make their records available to HHS. Make sure that you're not imposing unreasonable or impermissible practice restrictions, things like non-competes, unless it's part of an employment agreement or otherwise allowed under the recruitment safe harbor. You want to make sure that you don't prohibit them from establishing medical staff privileges or referring business to other entities, unless it fits within those limited exceptions under the recruitment safe harbor. You're going to want to define the benefits that you're going to pay. Are you going to pay just a one-time signing bonus, relocation reimbursement, student loan repayment, practice assistance, free or subsidized rent or equipment, income guarantee, whatever it may be. And you've got a lot of flexibility under the recruitment agreement safe harbor. You can come up with ways to do this. You just need to make sure that they're structured, that those benefits are consistent with the parameters that are set forth in the recruitment agreement safe harbor. And in defining all of those benefits, make sure that you take into account tax ramifications, because depending on whether the person's an employee or whether they're an independent contractor, there may be deductions that they may be responsible for. They may have to claim or identify certain payments on a 1099 or a W-2. Make sure that you condition those benefits and the ongoing payment of those benefits on compliance with the agreement terms, including practice requirements and qualifications. So if they fail to comply, your obligation to continue to provide those benefits terminates, and perhaps they've got an obligation to repay. Income guarantees are quite frequent, or quite common. You need to make sure that those income guarantees are structured appropriately. There's different ways to do it, but in general, they usually have a variation of the following. Usually it's structured so that it's set up with a maximum income monthly guarantee amount, maybe $15,000 or $20,000. From that, you subtract that physician's net income. Make sure that when you're defining what that net income is going to be, that you consider all income, not just from the practice at a particular group, but any collateral income that may come from like moonlighting or call obligations or all of those. From that income, you will usually subtract out the additional incremental expenses that are allowed under the Stark Recruitment Safe Harbor, and that, if you subtract that net income from the maximum monthly income guarantee, that gives you the income guarantee payment that you'll have to make. Make sure that when you're structuring that you identify what are the qualifying additional incremental expenses that are going to be able to be factored in. Remember, you're limited to only those additional incremental expenses that are that were caused by that physician joining the existing physician practice. You'll need to make sure that everybody's clear on what expenses can be counted and what can't be counted. I've seen situations where disputes arise down the road about what they can count and what they can't count. For example, I've started coming up with attaching an attachment that gives some kind of a budget along with the identified includable expenses or the types of expenses. And those expenses can't come above a certain level or above or below that level unless you can get approval from the entity that's paying the recruitment benefit. That's a way to protect the hospital. You should make sure that you've got a cap on the duration of the income guarantee. Usually you limit the income guarantee to only 1 year. It could be less. You want to put a cap on the total and monthly guaranteed payments so that once you've exceeded a certain amount, that's all that they get, either on a monthly basis or on an annual basis or both. A lot of times you'll have some kind of reconciliation or termination provision so that once the total income guarantees you've paid exceed a certain amount, that they don't get any more. Your obligation under the income guarantee terminates. You might build in reconciliation provisions. So if in months 1, 2, and 3, they receive the income guarantee because their net income did not exceed the guaranteed amount, but in months 4 and 5, their income exceeds that guaranteed amount, then you might have a situation where they have to repay that excess back into you to repay you for the amounts that you've done earlier. That's not necessarily required, but that's a way that you can minimize your exposure. You want to make sure that you require the documentation necessary to support the payments, to support the additional incremental costs or the income. You want to have a way to audit to make sure that you're not getting taken to the cleaners. And you want to make sure that you require them to implement good faith efforts and sound business practices in order to make sure that they're getting all the collections that they can so that they're not just out there playing and letting you pick up the tab. Your agreement should allow termination upon specified occurrences. For example, if they fail to maintain their full-time practice in the community or fail to maintain their qualifications, or you determine that the arrangement violates applicable law so that you've got an exit strategy and you can get out. So you no longer have to continue making those payments and or you can recover the amounts that were previously paid. You should require immediate notice if they fail to satisfy the conditions or qualifications so you now know so that you can take appropriate action and confirm the benefits and obligations cease upon termination of the agreement. You'll probably want to have a provision in there that if they leave early, they have to repay some or all of the benefits that you've paid for them. Now, those are structured quite often. Well, it could be either structured as a penalty so that they have to repay the amounts that come back, so that amount comes back to you, either as a pro rata portion or the total amount that you've paid, or quite often those are structured as a forgivable loan. So essentially you're paying out these benefits as if they were a loan to the individual, and that loan is forgiven so long as they stay over a period of time. But if they leave before the end of the time, then they have to repay all or part of the loan. If you are going to structure it as a forgivable loan, make sure it's structured appropriately. You'll want to usually have a promissory note. You'll usually want to take a security interest, for example, in group revenues, but make sure that you consider the tax consequences of that loan. For example, if you're hiring this person as an employee, there are tax consequences that come with the forgiveness of the loan as it goes along. If you are a public entity, you may be limited in your ability to structure this recruitment agreement as a loan because there may be limits on your ability to use public monies to loan to private individuals. You want to address whether, if they do leave early, if that repayment obligation is owed by just the physician or is it also owed by the group. You can structure that into the agreement. All right, those are kind of the key terms you want to have in your agreement. In the final couple of minutes that I've got left, I wanted to talk briefly about what you need to do to make sure you're avoiding recruitment problems. Well, first, beware subsidized existing practices through recruitment agreements. Remember, that's what they got the people at Weinbaum and the other people at Tenet Alvarado in trouble. So be especially careful if you're going to recruit a physician or a practitioner into an existing practice. Only recruit practitioners if there is a legitimate and documented community need, as we've talked about earlier. Never recruit somebody just because an existing practice that is a large referral source comes to you and says, hey, we want to get this new person in. We want you to subsidize our practice in getting them in. That's not why you do it. You need to make sure that you're documenting a legitimate community need for that service. Make sure you define the terms of the recruitment agreement in advance. Don't enter into like these oral agreements where you made promises, the physician group expended the money, and now they come to you and want you to reimburse them, but you didn't satisfy the recruitment safe harbor because you didn't have the recruitment agreement in place.
Do not pay more than is reasonably necessary to get the recruit to your service area. For physicians, ensure you comply with the Stark Safe Harbor and to the extent possible the Anti-Kickback Safe Harbor. That's when you want to, when you're doing this deal, pull out the Safe Harbor guidelines that I gave you, this copy of the regulations, and go through. Make sure your agreement satisfies each of those terms. It might make sense to make sure that you have that reviewed by your compliance officer or competent counsel to make sure that you don't unwittingly screw up. Be careful, because a lot of times your business people, your CEO, the people who want to do these recruitment deals, you know, they want to make physicians happy, and they're willing to offer a lot of things that may not be allowed under the regulations. So make sure those recruitment agreements go through your compliance officer. If you're dealing with non-physicians, ensure you comply with the Anti-Kickback Safe Harbor to the extent possible. If you can't comply with it, make sure you document community need. Again, beware of joint recruitment arrangements. Consider the tax implications of any benefits paid to the recruit. Make sure you strictly comply with the terms of the agreement once they come on. Ensure that the recruit performs according to the terms. Don't alter or renegotiate or waive the terms after the recruit arrives. Remember, that's that Stark advisory opinion where they found that they violated Stark by changing the terms afterwards. Don't overpay. Make sure you obtain and maintain documentation to ensure your compliance. Periodically review your compliance as necessary, and audit your payments as you go along. If there is non-compliance, make sure you terminate the agreement and then enforce the terms of the agreement. If we've been here and you think that you may have a problem with your recruitment agreements, don't sweep it under the rug. Don't hide it. Remember all those Stark penalties, the anti-kickback penalties, all of that can rain down upon your head. If you've got an improper recruitment agreement, you need to address those problems. That means suspend submitting claims by the referring physician until you get those situations resolved. It's one thing to submit a claim to the government when you didn't know there's a problem. There's another, it's a whole different thing to submit that claim when you know that there's a problem. When you know there's a problem, hey, that's submitting a False Claims Act. That's a false claim, that's a False Claims Act violation, maybe a fraud violation. Involve your compliance officer or competent counsel to review the situation, make any necessary corrections, which may include requiring repayments from the practitioner if you've overpaid. Enforce your contract terms and may need to require you to modify your policies or processes to avoid problems in the future. And if necessary, you may need to report and make repayment to the government. The government has separate, different reporting and repaying processes. If it's simply a Stark violation, the government has a Stark self-disclosure protocol, which quite frankly is very favorable to practitioners. So far, the government has only been requiring pennies on the dollars as long as you comply with the terms of the self-disclosure protocol. If it's an anti-kickback violation, you may need to do the OIG self-disclosure protocol. If it's simply an innocent mistake, no violation of the law, then you could simply report and repay to your contractor, but you've got to do so within 60 days or else it turns into a False Claims Act violation. In any of these self-disclosure protocols, there is no guarantee the government will go easier on you, but it's a lot better than failing or refusing to make the report and having them jump all over you if they find out about it. All right, additional resources. We've given you the written materials. A bunch of other stuff is available on the OIG's compliance website, including things like their compliance series, the OIG compliance program guidance that provides a lot of insights concerning recruitment arrangements, all of these other items. As far as additional resources we have here, not only dealing with recruitment and retention, but we have done past webinars on Stark, anti-kickback, and the like. All of our past webinars are available for download at our website. We have future webinars coming up. There's the schedule for the future webinars. If you do not receive the email alerts concerning those webinars and you would like to receive those, or if you would like to receive email alerts about the periodic client alerts we send out, by all means just send us an email. We'll make sure you're added to the list. If you have ideas for future webinars you would like to, or topics that you would like to see addressed, by all means let me know. Otherwise, I think that's it. If you have any questions about any of the things we've talked about today, feel free to shoot me a quick email or use that chat feature and I'll follow up with you. Otherwise, thanks very much for your patience. Hope you're doing well and be safe out there.